On the 22nd day of January, 2009, the following proceedings came on to be heard before the Honorable Bert Carnes, Judge Presiding, held in Georgetown, Williamson County, Texas. The story you are about to see is true. No names have been changed to protect anybody. We join the docket call in progress.
08-1001. Brockhausen versus Esperanza Andrade.
State of Texas, Erica Kane on behalf of Secretary of State Andrade Esperanza.
We are here on your motion.
Yes.
How much time, madam?
15 to 20 minutes, Your Honor.
I don't think it will take 3 minutes.
Thank you, Your Honor.
07-1014. State of Texas versus.
And I am.
And you are?
I'm attorney Orly Taitz. I came from the state of California.
If you're not licensed in this court and in this state, you're not allowed to practice law.
Sir, I have filed a pro hoc vice.
I haven't signed it, madam. Sit down so we can finish the docket call.
Later that same morning.
This is 08-1001. Jody Brockhausen versus Esperanza Andrade, Secretary of State, State of Texas. Come on up, please. Is it Ms. Orly Taitz?
Taitz.
Come up, please. We are going to do this up here, ladies. This seems to be a bad copy, but let me make sure I understand. You have not associated with any Texas attorney in this case?
I did not have an opportunity to. This lady is a mother of 6, and
I did not ask for arguments, madam. I asked a very simple question.
Yes, sir.
Have you associated with any Texas attorney?
I could not find one.
Have you ever tried a jury trial?
I have not done jury trials. And she did not ask for a jury trial.
I'm just getting an idea of your qualifications and your experience. Because to me, jury trials are kind of where the real testing ground is. Anybody can come in on a non-jury case, walk out, and claim that they have had a hearing. But until they have been tried and tested in front of jury trials, they haven't proven themselves. In my opinion. Have you read the State Bar Act?
Yes.
And the State Bar Rules of the State of Texas?
Yes.
And you have read the Texas Disciplinary Rules of Professional Conduct?
Yes, Your Honor.
This is an unsworn copy of the motion.
I just got it, Your Honor.
I'll tell you what. If you want to step over here and sign it in front of the clerk and swear to it under oath, I'll allow you, for the limited purpose of this hearing only, to appear.
I appreciate it, Your Honor.
Yes, madam.
Thank you.
Are you Ms. Kane?
Yes.
Ms. Kane, I have read the plea to the jurisdiction, and I understand your arguments. If you don't mind, I'll simply hear from the respondent and then indicate whether I need further argument on the case.
Yes.
Yes, madam.
Your Honor. One of the arguments was that the case was moot. However, Ms. Brockhausen did file timely. She did file before the election. This was an urgent matter, and could have been heard before the election. I understand that right now the election is over. However, the core issue is not moot. I have piles of documents showing that Mr. Obama was.
That's not what we're here for, madam. We are here for their plea to the jurisdiction. This is a very limited legal issue. And I don't want to sit here and give her a forum for her argument. I want to hear why this court has jurisdiction, which they have put in question here. That's what I need to hear about.
Sure.
Excuse me? Would you go get that camera from that man? Anybody else out there that has any kind of electronic device, they need to leave the courtroom immediately. Thank you.
Your Honor. First of all, Ms. Kane brought forward that case, all of their case, that federal case where quite often the plaintiffs were not found to have jurisdiction. This is a state case. Ms. Brockhausen has brought a case in the state court which is different. And therefore Ms. Kane's argument as to Hollenberg case would not be valid.
I'm still listening.
Additionally, the circumstances of the case have changed due to the fact that the hearing was scheduled after the election. We now have a different set of circumstances. Now, her case is not against the person that's on the ballot. Now her issue is the fact that the president in the White House is not there legitimately, that will have an usurper in the White House. And there has never been a case of such magnitude. There has never been a case showing that there is no jurisdiction for a citizen of this country in questioning eligibility of one that is in the White House. So, because the case has been moved until after the election, she actually got standing. She actually brought jurisdiction.
Okay. Is that it?
Yes.
The plea to jurisdiction is granted. Do you have an order for me, madam?
Yes, Your Honor.
Thank you. Thank you, ladies. I have signed the proposed order.
Can we be excused, Your Honor?
Yes, madam. That's all.
May I say something?
No, madam. You have a lawyer. That's why you have a lawyer here.
That's nice. I worked very hard on this.
Leave, madam. Did you get somebody to figure out how to delete that photograph? And if there's an audio recording that needs to be deleted also.
And thus concluded the proceedings, the first hearing of what would become a legendary legal career on the part of attorney, dentist, realtor and batshit crazy nutcase, Dr. Orly Taitz Esquire. Join us next time for another great moment in Birthism. Until then, this is Epictetus, leaving you with this thought. When confronted with daily challenges, take a breath, think for a moment and ask yourself, what would Diva Tell do? Goodbye and thank you for watching.